Hi, I'm Robert Tolpe. Tonight we will be talking about a teenage boy who killed 4 people and injured 9 while driving drunk and got away with it because he was rich. This story sounds familiar, if not boring, as wealthy people get away with all sorts of crimes because they can afford good legal counsel, but this one has greater implications than that. You see, his lawyer's defense was that Ethan Couch was too affluent to be held accountable for his actions. So let's talk about that, shall we? It was a clear Saturday evening on June 15th, 2013, in Burleson, Texas. 16-year-old Ethan Couch had just finished stealing 2 cases of beer from the local Walmart before hopping in his dad's pickup truck with 7 of his teenage friends. Driving on a suspended license, drunk off beer and high on marijuana and Valium, he was speeding along a winding road at 70 miles an hour, 30 miles over the speed limit, not paying attention to the danger ahead. Meanwhile, a shaken 24-year-old Brianna Mitchell had just stepped out of her SUV, which had spun off the road and crashed. A small group of people, including 2 people who lived nearby and a passing youth minister, had gathered to assist. Her mother, Marla, was on the phone with her. Brianna was explaining that she had gotten in an accident and needed help when Marla heard the sickening sound of a devastating collision. Ethan's Ford F-350 had swerved into the SUV, pushing it into the youth minister's car, which rolled into the path of an oncoming Volkswagen Beetle. The Ford flipped over and slammed head-on into a tree. Amazingly, Ethan and all 7 of his passengers survived, despite the fact that none of them were wearing seatbelts. But as for Brianna Mitchell and the others involved, they were not so lucky. All 4 people standing around the car were hit and killed, including Brianna, the 2 neighbors, and the youth minister. One of Ethan's friends was permanently paralyzed, and the rest had serious injuries. Ethan, however, was relatively unscathed. When Brianna's mom finally arrived on the scene, she was greeted to the sight of him bumbling around, intoxicated, slurring his words and bragging about how he'd get away with it, because, of course, his parents were very rich. Witness Corbin Clark remembers him talking to his friend, saying, "I'm Ethan. I can get you all out of this. Just remember my name and I'll get you all out of this." His blood alcohol level, even 3 hours after the incident, was 3 times the legal limit. After Ethan's arrest, the prosecution prepared their case, charging him with 4 counts of intoxication manslaughter and 2 counts of intoxication assault, looking to put Ethan behind bars for 20 years. But his defense had other ideas. They planned to use a now infamous variation of the insanity defense, called the Affluenza defense, a term used by Dr. G. Dick Miller, the psychologist hired by the defense, to declare Ethan Couch too rich to be guilty. This was not the first time the word came up during a trial. During the sentencing of Robert H. Richards IV, heir to the DuPont chemical fortune, who was convicted of molesting a 3-year-old child, his attorneys argued that due to his immense wealth, he would be mentally unfit for prison, and the judge agreed. He was sentenced to probation and rehabilitation and was allowed to remain in his 5,800 square foot mansion. As for Ethan, his defense team went even further and tried to establish Ethan's affluence as a bona fide mental condition. You see, under 46C of Texas State Criminal Code procedures, you can be declared insane if at the time of the offense you had a mental disease or mental defect that caused you not to know right from wrong. If the defense was able to successfully argue that Ethan's wealth and privilege rendered him unable to discern whether his actions were immoral or illegal, and that the inability to understand that constituted as a mental disorder or defect, he would be sent by the judge to a luxury rehabilitation center as opposed to prison. He pled guilty and appeared before Judge Jean Boyd Hudson for sentencing. This was not his first time in front of a judge. Ethan had a criminal history. 1 year earlier, police found him in a parked pickup truck, drunk, with a naked 14-year-old girl passed out in the seat next to him. What happened that night, we'll never know. But he was only charged with minor in consumption of alcohol and minor in possession of alcohol, and was sentenced to probation and community service. Ethan was accustomed to getting away with his bad behavior. He was mentally unfit to face the consequences of his actions, or so the defense argued. The judge agreed and sentenced him to 10 years of probation and treatment in a cushy private institution, as opposed to 20 years in jail. Throughout the trial, Ethan appeared to show no remorse. The public was outraged. This was unacceptable. How could someone's social class be an excuse to get away with murder? Unfortunately, this is the reality of class structure in American life. While some were keen to point out that juvenile offenders are usually given lenient sentences regardless of their socioeconomic status, In practicality, it's simply not true. Let's compare the case of wealthy 16-year-old Ethan Couch with an underprivileged 16-year-old who appeared before the same judge who gave Ethan such a lenient sentence. Eric Bradley Miller was an impoverished teen with a rough upbringing. His father had left him at a young age, and his mother was addicted to drugs. A far cry from Ethan's comparatively excellent and privileged upbringing by his two millionaire parents. Upon his sentencing for stealing a truck and hitting a 19-year-old man, Judge Boyd told the troubled teen, "The court is aware you had a sad childhood, but you are fortunate to have a grandfather who is so committed and loves you. I hope you will turn your life around." He was given a 20-year prison sentence. Not only did Eric kill only one person as opposed to 4, but he also suffered from 2 very real mental disorders, including bipolar disorder and depression, as opposed to the unrecognized mental impairment that Ethan was supposedly afflicted with, called affluenza. This comparison emblemizes the deep disparity between how the rich and the poor are treated in the criminal justice system. While Ethan's expensive legal team was able to wriggle him off the hook for a heinous crime, Eric's public defender landed him in jail. Many psychologists and legal experts have weighed in on the problems and implications of this ruling. Prominent psychologist Dr. Robin S. Rosenberg, in her article titled "There's No Defense for Affluenza," asserted that the psychological expert witness for the defense distorted fundamental principles of psychology to come to the ludicrous conclusion that the rich don't understand the consequences of their actions. She explained that the defense's argument that Ethan never learned his unlawful actions had consequences was fundamentally flawed because he would learn that bad choices had repercussions in other areas of his life. Though his wealth and privilege may have caused Ethan to expect his punishment to be lenient, he did not expect there to be no consequences for his actions, as the defense implied. Rosenberg is keen to point out that even if the defense's psychological conclusions were correct and Ethan had no concept of basic cause and effect, the sentence is still inappropriate because it doesn't make any effort to teach Ethan that his actions have consequences. How would sending Ethan to an expensive private facility help his affluenza? It wouldn't. If anything, it would exacerbate it. The last fundamental flaw of the defense is that affluenza is not a recognized condition, and the psychologist hired by Ethan's legal team presented it as such. They construed the state of being spoiled as a kind of developmental disorder, which is problematic, in that they outright invented a psychological condition to suit their needs and hoodwinked the judge with psychological mumbo-jumbo, as Rosenberg puts it, into giving Ethan probation as opposed to jail time. As for the legal implications of the case, Ethan's story is no outlier in the statistical sense in regards to his race and class. The average sentence for white Americans in federal criminal cases was 55 months, as opposed to 90 months for black Americans. Not only is there deeply rooted systemic racism in the criminal justice system, but the wealth gap between white and black Americans is astounding. And that gap in wealth is pretty concerning even amongst white Americans alone. The fact is that poorer people overall do not have access to adequate legal counsel and are often encouraged by public defenders to plead guilty or accept horrible plea deals, if they even have access to a public defender at all. This case in particular creates a dangerous double standard in criminal law, which makes one's wealth a valid reason not to be held accountable for one's actions. This precedent was just another step backward in the losing battle against class disparity in America. So what happened to Ethan Couch? Where is he now? Well, he broke the terms of his probation and fled to Mexico with his mother. The authorities extradited him to the United States, and upon turning 19, he was transferred to the adult court system and, despite the efforts of his attorneys, was sentenced to 720 days in jail by State District Judge Wayne Salvin. That's 120 days for each person that he killed. He was released on probation in 2018, but then was arrested this year for failing a drug test, though of course his legal team is fighting that arrest as well. As for his parents, both of them were arrested and jailed on various felony charges. So what do you think? Has justice been served for the actions of the Affluenza teen, Ethan Couch? Comment your thoughts down below, and if you enjoyed this video, don't forget to like, comment, share, and subscribe. It would mean a lot to me. I put a lot of work into these videos, and I hope you have a wonderful week. Bye for now.